Hey there, Chalk and Gavel listeners. Welcome back to the show that explores how the law shapes education one case at a time. Thanks so much for joining us as we get this podcast off the ground. And now that we're a few episodes in, we really want to make sure that we're giving you all the education law content that you want to hear.
And to do that, we're going to need your help. So first, please find us wherever you find your podcast and like, rate, and review us. Go ahead and leave reviews. Those are such a huge help for us as we continue to grow and develop the show. So leave a comment on Apple Podcasts, Spotify, wherever you get your podcasts. We'd love to hear from you and help us help others discover the show.
Yeah, and you can also go to chalkandgavel.com. We've got a feedback form there. You can tell us what you're liking, what you're not liking. Hopefully, there's not a lot of that second piece. But if
there is, that's okay.
That's okay. That's right. But we can use that stuff to make Chalk and Gavel better. You can also engage with us on social media at Chalk and Gavel. So thank you so much for joining us. And we really appreciate you giving Chalk and Gavel your time. Now let's get to today's show.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas, a former teacher and school attorney.
And I'm Jamie Kudlitz, a former teacher and middle school principal.
Now we're both professors of educational leadership working to empower folks with knowledge about the laws and policies that have a profound impact on our children and schools.
This is the show that tells the stories of how the courtroom is connected to the classroom.
What happens when a weapon is found on school property? What are the consequences and implications of zero-tolerance policies? Can a student be punished for a weapon they didn't even know they had? What phrase of undying love do you have engraved on your favorite hunting knife?
Today, we're going to talk about a case involving a student getting expelled for having a knife on campus.
Seems pretty cut and dry to me.
Oh boy. Come for the law, stay for the dad jokes, everybody. In today's episode, we'll reveal the story of Dustin Seal, Dustin's friend's ex-girlfriend, Dustin's friend's knife, and zero-tolerance policies. Stay tuned as we learn about Seal versus Morgan in a case with some major implications.
It's for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, everyone, before we start talking about knives and zero-tolerance policies, Chris, tell us about today's bell ringer.
Absolutely. So this is a topic that we've kind of been covering for a while now, but there's been a judicial decision on one of the curricular gag orders that we've mentioned earlier. Oh. So this is out of Iowa, a federal court in Iowa. And it was based on Iowa's version of a curricular ban that targets LGBTQ issues in the curriculum and in school libraries. So this is the case of GLBT Youth in Iowa Schools Task Force versus Reynolds. And it's a December 29th, 2023 decision, so pretty recent. Judge Locher. Locher? What's your best bet, Jamie?
The judge.
The judge, I like it, granted a preliminary injunction in favor of a group of students, teachers, and publishers who were suing to stop enforcement of the curricular ban. So the judge ruled.
Interesting.
Yeah, it is. And it's nice that we're starting to see some decisions on these laws, right?
Yeah.
So the judge ruled that the students were likely to succeed on their First Amendment challenge to the law, and that the law was unconstitutionally overbroad and vague given its expansive and ambiguous language. So this is at least two courts now who have struck down laws like this for, at the very least, being vague and overbroad. So, this is one of those cases that we will probably do a full episode on, or we might want to do a full episode on. But regardless, we'll definitely keep an eye on this and issues like it. But, at least for now, this ruling prevents Iowa from enforcing its curricular ban targeted at LGBTQ issues.
Wow. That is absolutely fascinating. Like you said, starting to get some of these decisions on these pieces of legislation. This is really fascinating. I think we should cover this case. That sounds like a good idea.
Yeah.
All right.
Great idea, me.
Yeah. Okay. Well, let's go ahead and dive into to today's case, Seal versus Morgan. A lot of interesting facts in this one. So you ready?
Always.
So here we go. It was a dark and stormy night. Well, we have no idea what kind of night it was but we know it was Halloween.
Oh, okay.
So dark and stormy kind of seemed appropriate. Yeah.
Mm-hmm. Yeah.
So the date was October 31st, 1996. The location was Knox County in Tennessee. So that's Knoxville area. Dustin Seal was a high school junior driving around in his mother's car because it's high school and his wasn't working, and that's what happens. So Dustin was driving to his girlfriend's house with his two friends, Ray Pritchard and David Richardson. Now, at this time, there was some apparent dispute, as the court records describe it, between Ray and the guy dating Ray's ex-girlfriend. Sounds like, pretty standard high school drama, right?
Mm-hmm. Did you drive your parents' car in high school?
No, I didn't drive my parents' car in high school. When I was 16, my dad gave me my first car, which was one of his business's old cars. It was a 1981 Chevy Malibu. The thing was massive.
That's not a bad first car.
It was a bad first car. No, it was a great. It was a great first. No, it was a great first car, and I was very grateful to have it. I washed and waxed that thing when I got it, and and that was the silliest thing to do, because this was like 1993, 94. This car probably had 200,000 miles on it at the time. It was beat up. It was the paneling, the material on the ceiling was drooping down, and I had it all thumbtacked up. And here I am waxing the car.
Yeah, that's going to do a lot.
Yeah, exactly.
So same. Well, I guess it technically was my dad's car, but mine was a 1996 Buick LeSabre. So you want to talk about big cars. Yeah. You didn't steer the Buick. You suggested which direction it should go.
All right. So let's get back to the story here. So Dustin is in the car with his two friends, Ray and David, and they're driving to Dustin's girlfriend's house on Halloween. Again, there was some dispute going on with Ray and whoever this guy was that might have been dating Ray's ex-girlfriend. But because of that drama, apparently Ray started carrying around a hunting knife. Now, this knife had a 3.5-inch blade, and it was engraved with the inscription, "Ray loves Jenny." Aw, young love. Isn't that nice? So the court documents don't really get into the engraving at all, but I'm kind of curious. Did Ray get the knife or engrave that inscription after he and Jenny broke up? Or was it like a gift to him from Jenny when they were dating, professing their love for one another? It doesn't matter, but I'd kind of like to know. Whatever. Some questions are going to go unanswered.
I'm going to make the assumption that that she gave it to him before they broke up. That's what I want to believe.
Okay.
Because
the other way,
the other version is a little sadder.
It's a little darker. Yeah. So anyway, on that dark and stormy Halloween night, Dustin was driving. It might not have been dark and stormy. Dustin was driving Ray and David and the Ray Loves Jenny knife to go pick up Dustin's girlfriend. Dustin knew that Ray had the knife with him that day and in the car. But that was possibly the extent that Dustin knew about the knife. When they got to Dustin's girlfriend's house, Dustin got out of the car and went to get his girlfriend. And during that time, David took Ray's knife and placed it in the glove box. So the next day, Friday, November 1st, Dustin drove his girlfriend and Ray to school, again in his mom's car, for the Friday night football game. Because after all, it's Friday night in the South, and that's what you do. Plus, the three of them were members of the high school band, and so they had to be there.
Sounds a lot like a lot of my Friday nights.
Yes, band guy Chris, yep, probably was.
Minus the knife in the glove box. Cannot make that clear enough.
It's good to know. So the very well-prepared teens arrived already dressed in their band uniforms. But when they got in there, they were told they didn't need to wear them after they arrived, so they went back to their car, which was parked in the school's parking lot, to change their clothes. After they changed, they went back into the school and were confronted by the band director, Gregory Roach. He pulled the two boys aside and asked them if they had been drinking. Ray denied it, and Roach let them in because he didn't smell anything. Case closed then, right? Nope. About 15 minutes later, Roach called the boys back into his office where they were joined by Vice Principal Charles Mashburn. And it seems like Mashburn had heard from 4 students that they had seen Dustin and Ray drinking.
Ooh.
He had also heard from one of the assistant band directors that they saw one of the boys with a flask and that the boys were chewing gum and checking each other's breath. Now, as we have mentioned before, all you need to have to conduct a search is reasonable suspicion. And these kinds of reports could easily amount to reasonable suspicion for a search. And it did. What I want to know, though, is were those 4 students who made the initial report friends of Jenny's new boyfriend? Because, that would be interesting, wouldn't it?
My question is so if the band director lets them in, when do they hear from those 4 witnesses, and when does the assistant band director let them know, hey, by the way, I saw them chewing gum and checking each other's breath, and maybe I saw them with a flask or whatever. I don't know, there's a timeline.
It's a little not clear.
But none of that really matters because
Mashburn searched the boys' coats and instrument cases and found nothing. So then he decided to search the car. Dustin consented to the search, and no flask was found.
But
you want to know what was found? Dustin's antibiotics that he had been prescribed, 2 cigarettes for which there was no prescription, and you guessed it, a knife with the inscription, "Ray loves Jenny." So Mashburn brought Dustin back to his office to write out a statement explaining why a knife was found in the glove box. And so Dustin's statement read as follows. Went to Roach's office because he thought or had been told that we had a flask and had been drinking. So we went and Mr. Mashburn searched the car. He found a knife and 2 cigs. The knife was there because Ray's ex-girlfriend's boyfriend had been following us around with a few of his friends, so we were a little uneasy. And that was the statement.
Yeah. Interesting that they made him write a statement that day. And I think, that's a good practice, right? To get everybody on record.
While it's fresh.
Mm-hmm.
Yeah.
Yeah. So I applaud the vice principal for doing that. The statement is really interesting though, because it's very factual. It doesn't admit to anything.
Mm-hmm.
It doesn't say he knew about the knife. The knife was there because we were, worried about what was going to happen with the friend's ex-girlfriend's boyfriend.
Right.
What gets me though is I don't know why Seal is getting in trouble. Why is it Dustin Seal who's getting in trouble here when the knife says Ray loves Jenny? It's obviously not
his knife.
Right.
Well, I think we're going to talk about that a little bit more.
All right. Hit me.
So Dustin writes out this statement, and now it's school discipline time. So Mashburn prepared a hearing form for a long-term suspension because long-term suspensions legally require more formal procedures than short-term suspensions generally do. We can thank a bunch of other court cases for that. And Dustin was charged with possession of a knife, tobacco, and pills. Mm-hmm. You want to read the policy, the school board policy here that this all pertained to?
Yeah.
Okay.
So this is what he ends up getting expelled for. So in pertinent part, the Knox County Board of Education policy, pursuant to which Seal was expelled, provides that students may not possess, handle, transmit, use, or attempt to use any dangerous weapon, including knives, in school buildings or on school grounds at any time, and that students who are found to have violated the policy shall be subject to suspension and or expulsion of not less than 1 year. The policy also provides that the superintendent shall have the authority to modify this suspension requirement on a case-by-case basis, although, as we'll talk about in a second, the superintendent here argued that it wasn't clear whether he had the power to modify a suspension or expulsion once it had been finalized by the board. And this policy is really, this is a standard policy. A lot of states adopted these zero tolerance policies that mandate punishment in the late 90s. Ohio has a very similar policy that got adopted at about the same time, and all of them mandate certain punishments for, in this case, carrying or transporting a knife on campus.
Yeah, exactly.
Which gets me, so, a little diversion here, personal story. In the early 90s, I got a pocket knife for Christmas, and I was so excited for it. I took it to show and tell at school. And, it's like a 2-inch pocket knife, whatever. I was in 2nd or 3rd grade. And I took it to school for show and tell. And I showed it to my teacher because I was just so excited for this thing. And my teacher's like, Chris, don't bring that to school ever again. Put it back in your backpack and don't get it out until you get home and leave it at home. And that was the end of it. Mm-hmm. But that was a small rural town in Ohio.
Times have changed.
And, I was a good kid. And so you can imagine if this zero tolerance policy had been applied to me, that's an automatic 1 year expulsion.
Right.
But
yes.
I just got a verbal warning to hey, put it back and don't take it out again.
Right. So a few days after all of this, the principal conducted a hearing and suspended Dustin pending expulsion for possession of a knife. And it doesn't look like the cigarettes or the pills were factored in. So Dustin appealed to the school board, and a couple of weeks after the incident, an appeal hearing was held. So at this appeal hearing, Dustin, his parents, his girlfriend, Ray, and David Richardson, they all showed up. So they got the band back together, so to speak.
Nice.
All right. It was a stretch.
I like it.
Sorry. Okay. So at this hearing, Dustin testified that he knew about the knife and that he knew that Ray had the knife on him when they were in the car on Halloween. But he didn't know that it was in the car the next day. David testified that he had placed the knife in the glove box while Dustin wasn't in the car, and that he had no reason to think that Dustin could have known where that knife was. Dustin's girlfriend also testified that she didn't think that Dustin knew where the knife was. A few days later, the board decided to uphold the suspension pending expulsion by the board. The reasoning essentially just stated that the decision was being upheld because, quote, possession of a weapon on school property is a violation of Knox County policy, unquote. So after that, Dustin's mother appealed, and the board heard the appeal at their next meeting on December 4th. So basically, it's just been 1 month since all of this stuff happened. Dustin had counsel at that appeal, and it was argued that Dustin had no knowledge of the knife's whereabouts when the car was on school property. One board member responded to that by lumping the cigarettes and the pills, again, which Dustin had a prescription for, back into the equation, stating that, quote, it doesn't just signify a weapon, and either of the three are justification, unquote, which is kind of interesting to bring those other two things back into the justification when the original suspension was just for the possession of a knife. right?
Right. And you've got to wonder, what is the punishment for having cigarettes? Like, is it a year suspension or expulsion? I don't think that's probably the appropriate punishment for cigarettes. Whereas we've got this zero tolerance policy, which specifically addresses weapons. So if you're punishing him for the pills or the cigarettes, I imagine that's going to be a very different punishment than a 1-year expulsion because you've got a knife.
Yeah. Well, whatever, the board member was basically just throwing all that stuff together, which was interesting. So, all right. So I'm gonna wrap up my piece of this here. So Dustin said he had never actually seen the knife in his car, and he had just assumed that Ray had taken it with him. The board member basically just said, too bad. We have to be consistent about sending clear messages to students, and you are responsible for what's in your car. Essentially saying that it didn't matter that it wasn't his knife. It didn't matter that he had no idea it was in his car. None of that matters.
Mm-hmm.
You know, you're responsible for what's in your car. We have a zero tolerance policy. We have to send a message to other students. So sorry, buddy. And the board unanimously voted to uphold the principal's recommendation to expel Dustin. And there you have it. The setup for a lawsuit.
Which the parents took that invitation, let's say. Before we get into the lawsuit, like, it just doesn't feel right to expel a student for something they didn't know they did.
Totally. Which is, this is one of the reasons why we're doing this case, is to sort of expose the often problematic nature of zero tolerance policies, right? Like, look, I get it. When it comes to student safety and school safety, like, we've got to be extra vigilant. I understand all of that. But at the same time, like, as this case kind of exemplifies, situations are very complex and nuanced, right? And are zero tolerance policies effective and appropriate in all of these situations? Mm-hmm. Anyway, it's a complicated debate,
and the policy itself acknowledges that, right? Like, it acknowledges that these are complex situations because it gives the principal discretion on whether or not to enforce the 1-year expulsion.
Right.
The principal can choose. And here, the principal obviously didn't exercise that discretion.
Right.
Which, so you can see kind of why Dustin and his father are really upset about this situation and why they make the decision to bring a lawsuit against the district.
Yeah.
So they file a federal lawsuit in the Eastern District of Tennessee. They make a number of claims against the school, the board, the superintendent. First, they allege that the search of the car violated the Fourth Amendment and Seal's right to be free from unreasonable searches and seizures. Next, they allege that the expulsion violated both the Equal Protection Clause of the United States Constitution and the Due Process Clause, also of the 14th Amendment. So then, we get through this lawsuit, things start going, and the school and the superintendent move for summary judgment. Basically, they're arguing here that, you know what, we've got enough right now. We don't need to go through the whole process. We think we win as a matter of law. And the court ends up agreeing and dismissing the Equal Protection Clause claim and the Fourth Amendment claim. So the only thing that is left is the question of whether or not Dustin Seal's due process rights were violated. And the court denies summary judgment on the due process claim and also concludes that the superintendent is not entitled to qualified immunity. Interestingly, though, Seal doesn't appeal any of this. He also didn't independently move for summary judgment himself. It was just the district that moved for summary judgment. And that's kind of unusual because often in cases like this where the facts are pretty much agreed upon, you'll have cross motions for summary judgment. Didn't happen here for whatever reason. Seal is kind of taking a back seat. The district is doing a lot of the, let's call it, legal maneuvering.
Okay.
So even more interesting, though, and this is where things get a little weird. The trial court, after denying in part and granting in part the school's motion for summary judgment, schedules a trial for damages on the due process claim. And that's weird because the district just denied summary judgment. It didn't say that Seal won on the due process claim. It just said the district didn't win.
Huh.
Yeah. So that's a really weird one because, in these situations, you'll have basically sometimes you'll have two trials, sometimes you'll just have two decision points where you've got to decide liability and you've got to decide damages. So like, are you responsible? And then if you are responsible, how much do you need to give the defendant or the plaintiff to make them whole? And here the court seemed to skip that first step, which the school and the superintendent did not like at all. So they end up appealing this decision. And that sets up the Sixth Circuit opinion in this case, where the Sixth Circuit has to address the question of whether or not, the trial court got it right and whether or not Seal's due process rights were violated and whether or not the superintendent should have gotten qualified immunity.
Interesting.
Yeah. So the only claim that Seal has alive on appeal is his due process claim.
Okay. Was that claim a procedural due process claim or a substantive due process claim?
Well, so he just brings a due process claim.
Okay.
And he tries to argue both. And, the kind of the two flavors of due process. One is procedural due process, where basically it determines how much process is due before the state can take away your life, liberty, or property.
Right.
And,
so
these are kind of the procedural steps.
Yeah, exactly. Like when it comes to, did the person get a hearing? Was there adequate notice provided? Did the school follow those concrete steps?
Mm-hmm.
I would say, would you agree, Chris, that most due process claims are procedural in nature as opposed to substantive, just because of how much more complicated substantive due process claims are kind of how much harder they are to kind of work through?
Let's call it the justifications you need to succeed on a substantive due process claim are pretty high, especially for something like this.
And it's pretty easy to know if a process isn't followed, right?
Right. Yeah. Whether a process is followed is usually black and white.
Right.
Though there's always questions about basically how much process is due, because the more significant the interest that's being taken away, the more process you need to have. So like school suspensions of 10 days or less really get minimal process.
Right.
There's a Supreme Court case, Goss versus Lopez, that basically said you just need notice and a hearing. And notice can be, hey, here's the allegations against you. And the hearing can be essentially, tell me your side of the story and I will present the evidence against you. And that's pretty much it. That's all you have to do for a suspension of 10 days or less. Once you get into expulsions, there's a lot more process that's required. And, the thing about due process is almost every state will have very clear procedural requirements spelled out in statute. So we're talking about kind of constitutional due process, but there's also statutory due process that we have to be aware of here too.
Okay.
And, here, Seal gets everything, right? Like he had an attorney, he had witnesses, he had a hearing, he had an appeal. He gets so much process.
Yeah.
So the real kind of issue that he's bringing is this idea of substantive due process. And so substantive due process is kind of a flavor of due process that essentially recognizes that some interests are just so important or fundamental that no amount of process is going to be enough to justify the government taking it away from you.
Interesting.
And so the state could give you every conceivable procedural protection, but because of the importance or of the interest or, the lack of justification, that wouldn't be enough. And so it protects citizens from arbitrary or irrational or unjustified governmental action. So, think back to our last episode, San Antonio versus Rodriguez, the Supreme Court has declined to recognize education as a fundamental right. So it's not a fundamental right. So that means it's not deserving of kind of the strictest judicial scrutiny.
Okay.
So here in the school discipline context, in order to succeed on a substantive due process claim, it's only going to happen in the rare cases when there is no rational relationship between the punishment and the offense. And so this is why we were talking about it's so hard to succeed on a substantive due process claim in school discipline, because it has to be irrational.
Mm-hmm.
And here the court finds that this is one of those rare cases where it is actually irrational. The court concludes that there's no rational relationship between punishing someone for a knife that they didn't know they had and the school's interest in maintaining order and protecting students. The court basically asked just, how can this student be a threat with this knife if he didn't even know he had it?
Yeah.
And so the court says, suspending or expelling a student for weapons possession even if the student did not knowingly possess any weapon, would not be rationally related to any legitimate state interest. No student can use a weapon to injure another person, to disrupt school operations, or for that matter, any other purpose if the student is totally unaware of its presence. Indeed, the entire concept of possession, in the sense of possession for which the state can legitimately prescribe and met out punishment, ordinarily implies knowing or conscious possession. So that's what the court says about this whole thing. And the school tries to get around that.
Wait, are they basically saying it doesn't meet the definition of possession if you don't know you have something?
Right. Yeah. The legal definition, like you can't possess something you don't know you have, is essentially what they're saying.
Interesting.
Yeah. And so the school, they're trying to argue that there's no knowledge requirement here. It's a zero tolerance policy. It's in the name, zero tolerance policy. Putting aside, of course, that there's an exemption to the zero tolerance policy where the principal can basically decide to do whatever they want anyway. But, it's in the name, zero tolerance. And the court is really dismissive of this argument. And they use some pretty, I want to say, clipped language here. They get a little snippy about it. So in response to this argument that knowledge isn't required, the court says that we would have thought that the idea that possession implies knowing possession so obvious that it would go without saying. So, they're throwing some barbs back and forth.
Right.
And at oral argument in this case, one of the judges asked the school's attorney if the policy would apply to a valedictorian who has a rival slip a knife, unbeknownst to them, in their backpack. And the board's attorney makes a fatal error and initially says, yes, the policy would apply because that person has a knife. And then the attorney probably sees the judges react like, hey, that's crazy.
And then they try to walk it back.
And they try to walk it back. So he reads the attorney reads the room, backtracks a little bit and says like, oh, you know what? Maybe in that situation, there'd be an argument for leniency. And, the question that I would love to hear follow up with that is, so why wasn't there any leniency given in this case?
Yep.
So ultimately the court remands the case back down to the lower court to determine why the school expelled Seal. So did they disbelieve his argument that he didn't know the knife was there? Because if that's the case, if they just didn't believe that he didn't know, then suspend him.
Then they've technically got justification. Yeah.
Right. Yeah. Because you basically at that point, it's just a question of trustworthiness. Like, do you believe this student who's, got this excuse for why they shouldn't be punished?
Right.
And that's something that, courts aren't going to look at all that closely, And so essentially the court just wants to know, like, why did you expel this student? Because if you did it because you either didn't decide his knowledge or because you believe that he didn't know about it and you expelled him anyway, that's not going to do it because that is irrational and that violates his substantive due process.
Okay.
That seems to be the right result, right? Like we don't want students to be punished for things that they didn't know they did.
Right.
Right. Because this isn't even like I didn't know it was against the rules. This is I didn't even know I was doing the thing I got in trouble for.
Right. And it really highlights the challenges that zero tolerance policies present. Right.
Yeah. So then the court remands this back to the trial court. And before any of that can kind of play out, Dustin Seal and the school end up settling the lawsuit for $30,000 in December of 2001. And so after all of that, they settle for $30,000 and that's the end of the story.
Wow.
Yeah. Seems like a lot to go through for $30K, right?
Yeah. But wasn't one of the comments made something about that Dustin Seal was like, I don't want to keep doing this. Like I'm done. I'm done. So I'm just going to settle.
Yeah. The district kind of exhausted him. But even for the district's perspective, like, I don't know. This is one of those ones that kind of gets you.
Yeah. It's almost like a fizzle out and you're like, wait, after all that, this is where we end up.
Right.
But, still some important takeaways.
Absolutely. And then the last issue that the court deals with is the superintendent's qualified immunity claim. And we've talked about qualified immunity in a previous episode. So qualified immunity just generally shields government officials from civil liability for performing discretionary functions, as long as those activities or that conduct doesn't violate clearly established statutory or constitutional rights, of which a reasonable person would have known. Yeah. And so there's this question here of, is it clearly established, and would a reasonable school administrator have known about this? And the court essentially says, the right to be free from unreasonable searches and seizures, like that's pretty cut and dry. We know about that one. And, here the superintendent tries to argue that, or the superintendent does argue, that whether or not zero tolerance policies required knowledge, like that was not clearly established. That's kind of an open question that this case answers. So the court says, you know what, you're right. Like you couldn't have known that because we hadn't decided it yet. So you do get qualified immunity here because it wasn't clearly established that you couldn't expel a student for not having knowledge of the knife that they were punished for.
Yes. So were there any dissents in this case?
So there's one dissent. It was a 3-judge panel. 2 judges joined the majority opinion, 1 dissented. The dissenting judge would have just said, hey, you know what? This isn't irrational. This seems pretty rational to me. The policy, it's a zero tolerance policy. It doesn't have a knowledge requirement written into the policy. So I don't know why we judges are adding one because, this is just outside of our expertise. If they think this rule is necessary to keep the school safe, that seems pretty rational to me. I'm not going to second guess it. And a number of courts have kind of looked at similar issues with these zero tolerance policies. And that tends to be the approach a lot of courts take with these is that, we're not going to read a knowledge requirement into these policies that don't already have one. Obviously, the Sixth Circuit comes out differently based on the majority here. And I tend to think that majority approach, that knowledge is required, seems to be the better approach. But at least one judge and, a handful of other cases do come out the other way.
Yeah. I mean, it's a fascinating case. Keep in mind, this was 1996, the incident was 96. And a lot has happened since 1996 with respect to weapons in schools and school safety and things like that. Right. And, it's, on one hand, we say that there's aspects of this case that are very cut and dry and that's a punny knife joke and everything, but it's not so cut and dry. These situations are highly nuanced and really, really complicated, especially in light of all of the safety concerns and issues, that have come up in the last 30 years. There's not a lot of good answers to all of this because, again, when it comes to searching, when it comes to zero tolerance policies for weapons and things like that, when it comes to all of that stuff, it always comes down to trying to strike the right balance, right? Between taking somebody's rights away and maintaining the safe and orderly and efficient operation of the school and protecting everybody else's safety. It's a really delicate balancing act. And courts have generally, correct me if I'm wrong, Chris, courts have generally in the last 20 or so years tended to provide schools with a lot more leeway and flexibility if they are considering taking away certain rights in order to maintain the safety of their campus, right? Courts have been a little bit more generous, I guess you could say, towards schools in light of the things that have happened at schools.
Right. Yeah. So the courts, in the last few decades have definitely privileged schools' interests in maintaining safety and, protecting students over students' rights in a lot of important ways. Though, Steele, this case is an example where there is a line here.
Sure.
Where it's not, complete discretion because these rights are still meaningful and still important.
Yes.
But it is like you said, Jamie, there's so many issues within these cases and there's so much nuance because you can completely understand, we need to keep knives out of school. Yeah, absolutely.
Yeah.
I don't think anyone in this case would disagree with that.
Right.
But, it's that question of okay, but
Yeah. What happens if you find one? Are you just going to drop the hammer or are you going to consider the circumstances?
Which really gets at these zero tolerance policies, right? These zero tolerance policies tell you must drop the hammer.
Yeah. And, the other thing that the courts have generally sided with schools on is when it comes to the safety piece, how imminent is the threat, right? Because the more imminent the threat is, the more leeway a school has to react. I don't want to say harshly, but assertively. Yeah. Thank you. So like I'm thinking in this case, the knife was found in the car. It seemed to be pretty clear that no one was motivated to use it necessarily. The person who got disciplined for it didn't know about it. So like when it comes to, was there an imminent threat with this knife? It's very different than if you know that two students have a beef and have been going at it for weeks, and one of the students is found with the knife in his back pocket and he's on the way to where this other student was. Like, that's a very different scenario.
For sure.
So anyway, I mean, I just think that this is a case that really illustrates the complexity of these kinds of situations. It illustrates how potentially problematic zero tolerance policies can be.
Mm-hmm.
One of the things we read about this is how this case kind of consumed the family after this. And so these policies really, when you're going to expel somebody, you're going to affect their life. One of the things that we talk about with our students all the time, our aspiring administrators, is like, you make decisions on a daily basis that really affect people's lives. So you have to be very, very, very thoughtful when you do make those decisions, because they can have a significant impact on somebody's life. And that doesn't, that's not to say you shouldn't make that decision, but it's just something you've got to think very hard about, right?
Right. And in this case, like, I feel for everybody in this case, right? Like,
totally.
But the principal who ends up making the initial decision to suspend him pending expulsion, like, made some statements where, like, they didn't feel like they had a lot of choice,
right,
because of this zero tolerance policy,
right?
And reading the policy, there is that carve out right there. And so, one of the things that Jamie, you and I kind of really hit on with this podcast is like helping school leaders realize where there's room for discretion, even within these laws that don't seem to give you a lot of leeway.
Yeah.
And because there's a lot of ways that this situation, could still be handled to meet everyone's needs that aren't kind of the blunt instrument of zero tolerance policies.
Right. Right. Well, a lot to think about there. So we hope you enjoyed Seal versus Morgan today. We got a lot of great cases coming up. We've got, in a few weeks, we're going to be covering the Kennedy versus Bremerton case, and we got a great special guest coming on that one.
I cannot wait.
Yeah, we're really excited about what we got coming up for everybody. So without further ado, Chris, please give us our homework.
Go get your hunting knives engraved, and then go follow us on social media, follow the podcast, like, rate, review us wherever you get your podcasts. That's so important for helping us get the word out. We'd love to hear from you, so you can hit us up on our website or at our social media at Chalk and Gavel. The website's chalkandgavel.com. Please share the good word about the podcast with your friends, colleagues, your network. Help us get the word out and share what we're doing. Yeah, I think that's it.
Okay, well then that does it for this episode of Chalk and Gavel. Thank you so much for listening. I'm Jamie Cudlitz.
And I'm Chris Thomas.
Now join us again in 2 weeks when we continue to explore how the courtroom is connected to the classroom. See you then.